Okay, folks. All right, folks. Again, my name is Doug Pinkham with Pinkham and Associates. We are now going to go over the FL 342A. This is the non-guideline child support findings attachment. It's just a one-page form. Let me explain this form real quick. Again, this is an attachment form that goes with another form. It goes with some kind of child support order, a judgment, order after hearing, some other kind of child support order. Now, a non-guideline, start over. Okay, folks, again, this is Doug Pinkham with Pinkham and Associates. We are a dedicated family law firm here in Orange County, California, but the videos I'm helping you with are for forms that are good throughout California. All right, so this particular video is on the form, the FL 342A. It is a non-guideline child support order findings attachment. So this is the form that you're going to need, and you're going to need to attach it to your order or your judgment if you're agreeing to or if the court orders a non-guideline child support amount. What is a guideline child support amount? A guideline child support amount is that amount of money that gets kicked out of the computer when you use a child support calculator. You can find them online. They're DisoMaster, X-Spouse. There's some other computer programs out there that will kick out a guideline support order. You put in your income, father's income, mother's income, the other party's income, the amount of timeshare you have with the kids, the amount of timeshare they have with the kids, and then the other factors. If you have a house, how much you're paying for taxes on the property, and interest on the loan. There's a bunch of different factors. Whether you pay, there's a bunch of factors. When you put all that into the calculator and you press enter, the number that comes out at the other end is the guideline amount. California law says the judge shall charge guideline child support unless there's some significant reason why they can adjust from that. If the judge adjusts from that, you need this form. If you and your spouse or the mother or the father of your child are agreeing to a number that's different from guideline amount, you need this form. All right, folks, let's move on to the form. Just like all of these forms. Oh, by the way, I know that some of you can see the video or see the form on the video. That's fantastic. Follow along as we go along, line by line. If you cannot see the form on the video itself, there's going to be a link here. Click on it, print the form out, and have it in front of you so you can go line by line through the form as we go. All right, let's start at the top of the form. Petition, just like all of these, petitioner and respondent and the case number need to be listed at the top. Now, the next box, it says this form is attached to, attachment 2, and check the appropriate box. Is it attached to your judgment? Is it attached to an order? Is it attached to a 342A? Which, by the way, if you have a child support order, you're going to need a 342, and if you're agreeing to a non-guideline support, you're going to need to attach this A to the regular 342. All right, folks, moving down. Stipulation to non-guideline orders. So if you guys are agreeing to a number that's other than guideline, either higher than guideline or lower than guideline. Let me be specific. Let's say you run all the calculations and the guideline child support amount comes out to $863 per month. But let's say let's say dad's paying child support, and let's say dad says, I don't care about that number. I'm willing to pay $1,000 a month. Let's just make it $1,000 a month. That's a above guideline child support order. You need this attachment, and you're going to fill this out accordingly. Let's say, for example, the child support order, the guideline child support order comes out to $863 per month, but you guys are agreeing to $500 per month. That's considerably lower than guideline. You're going to need this form. So fill it out appropriately, whatever it is, either above guideline or below guideline, either way. All right, so number one, if it's an agreement, that's what stipulation means, agreement. So if you guys are agreeing to a different amount, mark 1, and then mark whether you're agreeing to a number that's above guideline support or below guideline support. Then let's say you're agreeing to a number that's below. That's pretty common. And let's say the statewide child support guideline, the amount of support that would have been ordered under the guideline formula is. So they're asking what the guideline amount is. And let's say we figured it out and it was supposed to be $863 per month. You need to put that in there. Okay, and then it says the parties have been fully informed of their rights concerning child support. Neither party is acting out of duress or coercion. So you know, and the needs of the children are going to be met by the order that you guys are going to agree to. All right, let's move on. Order, rebuttal, factor, other rebuttal factors. So support calculations. So the guideline amount of child support calculator is $863. Let's see, per month payable by, and let's say it's the respondent that should be paying child support. The court finds by a preponderance of the evidence that rebuttable factors exist. The rebuttable factors result in an increase, and we've agreed that we're going to do below, decrease in child support. That's if you're going to agree to a number that's below guideline. The revised amount of child support is whatever you guys agreed to. My example, I was going to say $500. The court finds the child support amount revised by these factors is in the best interest of the child, and that application of formula would be unjust or inappropriate in this case. These changes remain in effect, and I would put until further order, until further court order. You can put a specific date, but then you're just asking for a new court date or asking to go back into court on some date. So just put until further order of the court. The factors are, and you're going to need to mark a couple of these, or 1 or 2 or 5 of these, whatever it may be, depending upon what if they are appropriate. D1 is the sale of the family residence is deferred under Family Code Section 3800, and the rental value of the family residence in which the children reside exceeds the mortgage payments, homeowners insurance, and property taxes by, and if it exceeds it by, say, $400, then put $400 in there. Whatever it may be, if that applies. 2, and then if that applies, you're going to mark 1. Let's act as though that is not our factor. That doesn't apply. 2 says the parent paying support has extraordinarily high income, and the amount determined under the guideline would exceed the needs of the child. Okay, so this is a special code under 4057B3. Let me explain this. Let's say, for example, I had a client. I'll just use an example. I won't give his name, so it's okay. But I had a client one time where his father and he ran a company where they were involved in the sale of stock. In fact, they owned a company that every time a broker bought stock through them, they got a couple of pennies. Well, those couple of pennies added up to millions and millions of dollars per month. My client alone earned $1 million a month. As a result of that, the guideline child support, and by the way, he had a baby with this gal. They weren't married. Only my opinion, but it seemed like the gal thought she'd hit the lottery and she was going to be getting, $40,000 a month in child support. We ran the numbers, and they would have been some insane amount of money that he would have gotten. This is one of those cases where there was an extremely high income level. A court is not going to give guideline child support under that kind of a situation in the greatest majority of the time. It's very, very unlikely that they're going to run that calculation with those numbers and then give, say a non-working mother, especially if you're not married and hadn't lived that lifestyle, that kind of money. It's going to be a healthy child support order, don't get me wrong, but it's not going to be the guideline amount. So under that circumstance, there's going to be a lower than guideline amount. And if you're in that kind of situation and that's why you're agreeing to a lower amount, then 2 would apply. It's very, very rare. So if that does not apply, we'll move on. 3 says and it's either the petitioner or the respondent, is not contributing to the needs of the children at the level commensurate with that party's custodial time. If that applies, mark it. 4. Special circumstances exist in this case. Special circumstances are, and these are probably the more likely situations. Sub I says the parents have different timeshare arrangements for different children. So let's say, for example, you guys have 3 children, 2 girls and a boy. The 2 girls are with mom most of the time and with dad every other weekend. The boy is with dad most of the time and with mom every other weekend. And of course you stagger the weekends so that the children are all at the same house every other weekend. But in that kind of a situation, mom would have 2 kids most of the time and dad would only have 1 kid most of the time. As a result of that, it would mess with the child support, and you could work on the child support amount as a result of that. The parties have a substantially equal custody of the children, and one parent has a much lower or higher percentage of income for housing than the other parent. So let me explain what that means. That is, let's say, for example, you guys have a 50-50 custody arrangement. You guys live, 2 blocks apart, and you have a 50-50 custody arrangement. You guys both work full-time, but let's say you're even using the same daycare provider that's, in the neighborhood or something. But dad's income is $130,000 a year and mom's $50,000 a year. Under that circumstance, even though you have 50-50 custody, dad would definitely be paying mom some child support because his income is so much higher. But in that kind of a situation, let's say dad's housing costs are $5,000 a month and mom has an apartment at $1,200 a month. Those are the kind of circumstances where you could agree that neither of you will pay the other one child support, or the child support would be a very low amount of money. And that's what B is about. Or excuse me, it's not B, it's sub 2. Sub 3, I says the child has special medical or other needs that require support greater than the formula amount. These needs are, and these are special needs. And you're going to want to spell it out underneath there. So if there's healthcare needs, or there's, child care needs that are much higher than standard because the child has special needs, or whatever it is, or medical care, extra medical care is needed for the children or something like that. That's where this would apply. But this would be for above guideline child support. So let's say the guideline support was $863, and you might agree to $1,200 a month because there's an extra $300 or $400 a month needed for that nursing care or whatever it may be. That's what sub III means. All right. Then 4 is other. And this is some other special needs or special issue or special requirement or unusual thing. If you're agreeing to something, it could go under here. If the judge orders something different, it could go under here if it doesn't apply to something else. Anyway, that's the end of this form. That's the non-guideline child support findings attachment. If you are agreeing to a child support order that is not guideline, you must have this form. You must attach this form to your regular child support form, the FL 342. All right, folks, I hope this video has been helpful, and I'll see you.